was paid a package, but it was the case that responded was responsible by the issue of CNA, comparing that it was unfair and limited. I'm just want to bring on board the consequences that judges you have actually been doing, and therefore probably it is possible. The role of regional bodies such as EAMJA, what is our role, and probably this is why we are discussing. Promoting legal training across border unified force. We have to higher land labor disputes, labor rights principles important to students, but the Employer Association and Trade Union across countries have a role to play. We have ATE in Tanzania, we have FKE in Kenya, and Uganda we have reference for fuel. Probably these are the bodies that should help out to see and trade unions in those spaces. But what are the areas of consideration? Economic disparities, we have the use of ILO conventions and looking into other countries. What are the ILO conventions that they've ratified and what is the movement looking at disparities as well? Social impact differences, yes, these are inevitable, but then the core principles of legal justice and sure they don't be the different. What are the recommendations that I want to bring on board? Cross-border legal training, exchange programs such as this one, establishment of exchange, of electronic exchange of data between courts. This one I couldn't find out, and I would like to be educated if there is a cross-border exchange of legal cases or a platform that people can share. Promoting private sector roundtable forum to enhance business dialogue. I know in my space we do it, but in this space, like in Tanzania, we do labor, the tripartite class where the labor court is actually calling the social partners and the class. So can we have that probably in East Africa so that we can continue challenging ourselves? Bilateral arrangements, I've spoken about it, continuous engagement by the court and tripartite units, coaching with students, and the breach of employment.
So I'm going to give us the clap of this session, and I'm just going to demonstrate once, and we will repeat, and that's going to give up. So we'll open our hands wide like this, and bring them together and say, oh yes. Repeat again, oh yes. So thank you so much, Susan. I can see now you are full house. For information of the people who have joined us as we are ending the session, this is section 4. Our theme is enhancing labor dispute settlement resolution system to foster a favorable investment environment in South Africa. Our speaker has spoken on harmonization of labor laws and support to students in South Africa to improve dispute resolution. And our takeaway in terms of a good place to start, you see that's 2 minutes or a meeting on a minute now. A good place to start in terms of harmonization in labor laws in South Africa is the application of higher law conventions, which has talked directly on. And my take would be that where we have not ratified a particular convention, we may want as judges and magistrates to look into the recommendations and those conventions which can be applied to fill in the lacuna in our laws as soft laws. They are not binding, but they can guide the courts into getting a solution to the issues at hand where our laws have gaps. I believe we are all members in the East Africa of the ILO, so that would be a good place to start. Moving on to our next speaker, under the program is Justice Lady Justice Lilian Tumsime Mungisha. She tells me Tumsime. Tumsifu. So I think it's a easy name to pick for us from the East Africa. I'm looking for the bio of our next discussants. Just a moment. Yes, I'm going to highlight Salong's CV. I'm just going to highlight and just tell you about Lady Justice Linda Lilian Tumsime Mukisa. She's a judge of the Industrial Court of Uganda. She's the head of that court. She has an MBA from ESAMI, an MA in Development Studies in Governance and Democracy, and she has a Bachelor's of Law from the Makerere University. Just highlighting some aspects of her CV. Her experience, she's been the head judge from 2014 to present. Those are almost 10 years as the head judge of the Industrial Court of Uganda, overseeing labor disputes, contributing to court strategy and harmonizing labor laws in the Republic of Uganda. She has been in the past the Director of Legal Services, Directorate of Ethics and Integrity, the Chief Legal Advisor on anti-corruption matters, leading legal reforms and representing Uganda in international anti-corruption negotiation. She has in the past also worked on children matters. CV is long. I believe we can access it from, it will be shared by the committee. So allow me to welcome our presenter, Justice Linda Tumsime Mukisa. Karibu. You have 10 minutes. Thank you.
Thank you very much, Madam Moderator. My Lord, the Honorable, the Chief Justice of Tanzania, my Lord, the Honorable, the Deputy Chief Justice of Uganda, the President of EAMJA, my Lords, my ladies, your worships, ladies and gentlemen, greetings from Uganda. I am very happy to be here today. I would like to make a correction. I became head judge of the Industrial Court in 2023. Before that, I was judge of the Industrial Court. The Chief Judge of the Industrial Court Emeritus is here today, Justice Ntenje. Please stand up for recognition. He started off this court, which had been in abeyance for over 7 years. I would like to appreciate EAMJA for giving labor justice space to discuss labor laws and labor justice jurisprudence in this forum. I am a very firm advocate for a labor judges forum, and I believe that this forum, we will be able to set up one. I would like to first to thank the presenter for your brilliant paper, and I'll just build on and highlight some of the aspects from the perspective of Uganda, and also give my thoughts on what I think we can do as the East African community to improve harmonization of labor justice. As we all know, the regional economic communities, the African Continental Free Trade Area, ECOWAS, COMESA, SADC, represent monumental steps towards economic integration in Africa. They represent the potential for huge transformation to foster sustainable development, enhance regional connectivity, and create a unified market that promises to redefine Africa's future, trajectory, and role in the global economy. In our emerging economies, labor follows services, goods, and capital. The more these factors interact and integrate, the more conflicts are likely to arise due to increased avenues of relations. Labor laws and courts need to afford equal legal protection to citizens of these regional economic communities to enable free movement of persons and capital. So I cannot overemphasize the essential role of stable, predictable, and conducive legal frameworks and dispute resolution mechanisms in fostering a favorable climate for cross-border business. The extent of harmony in laws and in dispute resolution mechanisms is crucial, as the speaker, our presenter stated, to a favorable investment climate in East Africa and the entire region. And there is therefore urgency in this. I'll give a bit of statistics. The IMF Regional Economic Outlook for Sub-Saharan Africa, published in October 2024, the lingering effects of COVID-19 and increasing debt burdens are diminishing the resources available to development spending in East Africa. The projected regional growth rate of 3.6% for 2024 is relatively subdued and uneven, although a modest recovery is anticipated in 2025. The East African region is grappling with low growth rates and insufficient job creation. The lack of adequate employment opportunities is likely to exacerbate poverty and food insecurity, heightening the risk of social unrest and instability. The same report forecasts that half of the world's new workers will emerge from sub-Saharan Africa by 2030, necessitating the creation of up to 15 million new jobs annually. This underscores the urgency of our discussion here today. To supplement the presentation ably made by our keynote speaker, allow me to focus on three aspects. One, the ongoing efforts at harmonization of labor laws in Uganda, the work of the courts in Uganda, what is referred to as judicial pathway to harmonization, and lastly, share a few outstanding challenges and recommendations going forward. First, like Tanzania, Uganda has followed the three-pronged track to harmonization of labor laws. First, through ratification as a signatory to the ILO conventions to engage with international development or compulsory labor, the effective abolition of child labor, and the elimination of discrimination in respect of employment and occupation, as well as safety and healthy working environment. Uganda is yet to ratify the Convention on Occupational Health and Safety, 1981, which applies to all branches of economic activity. However, it has in place an Occupational and Safety Health Act, 2006, which regulates matters concerning occupational safety, health, and welfare. At the regional level, Uganda recognized the commitment under Article 126 of the East African Community Treaty for member states to harmonize all national laws that appertain to community. And as part of the community, Uganda has undertaken to harmonize labor policies, programs, and legislation, harmonize national social security policies, laws and systems, and confers precedence of community organs, institutions, and laws over similar national ones. Similarly, in the COMESA Treaty, one of the specific undertakings for Uganda is to harmonize or approximate its laws to the extent required for the proper functioning. Oh, I have 3 minutes. We have followed, and the Ugandan Parliament in the last 2 years overhauled its labor laws and significantly changed the labor landscape, bringing it closer to the spirit of the East African and COMESA, and our laws are similar to what the key presenter stated this morning. In the same time, I thought I would give a bit of comparison that the existing laws, we have also done something on existing laws in immigration, citizenship, and nationality, and have also provided for circumstances to ease the participation and employment of persons, especially from the East African community. These are all welcome developments amidst our differences in legal culture and substantive procedure laws. Now, however, there remain some areas that call for more work, which I thought we would need to highlight. For instance, the scope of protection, or who is excluded. Workers in the informal sector, I looked across the board, workers in the informal sector are often lack sufficient legal protection, especially as formal sector employment declines and is replaced by informal work. This trend leaves most workers in the East African community without adequate legal protection. And although some countries have done some work, the distinction between employment of service and employment for service highlights this issue as a labor protection are typically reserved for formal employment, leaving many workers vulnerable. The elimination of child labor, all partner states have partnered with the ILO international programs on child labor, and while there are strong legal agreements on abolishing child labor across the countries, discrepancies exist regarding the minimum age for employment and scope of prohibitions. For example, Tanzania prohibits employment of children under 14, while Kenya sets it at 13 and Uganda at 12. There is need to harmonize that. Recognition of virtual workplaces with the rapid advancements of technology in the workplace is transforming employment dynamics, particularly with the rise of the e-government and online work platforms such as Uber and Global. The traditional control test for defining employment relationships may no longer suffice, as seen in the UK Uber case, which distinguish between workers and employees, highlighting the need for clearer definitions and protection for workers in gig economy, which have become very popular. Additionally, there is a blurring of workplace boundaries, challenges existing laws that define workplaces as designated physical locations, leaving virtual workplaces unrecognized and potentially exposing to risk. There is also a conflict of laws with regard to termination of employment, which we need to look at. The different laws discuss termination of employment from different perspectives. The issue of non-discrimination clauses, where there is need for us to look at harmonizing aspects of discrimination, especially given that we require free movement of laws. My time is up, but in addition to our presenter, I think that we need to highlight areas of progress under judicial pathway harmonization, look at obligations of employers and migrant workers, the need to harmonize the computation of quantum of damages in employment matters, because this varies. In Kenya, I think the maximum is 12 months. In Uganda, it is open based on each case. There is need to have issues of mutual recognition and enforcement of judgments. The question I had in my mind is if there's a decision in Kenya against a Ugandan, a decision in Uganda against a Kenyan, and who leaves the country and has no assets, what happens? And there's need for us to also harmonize the institution structures. That's the expansion of policies and institutional structures. In Kenya, for instance, they have 21 labor judges. Uganda has only 2. I don't know how many Tanzania has. I know they have a division. So the paper is available. You will have, I had so much to say, but the time is short. And I hope that in future we shall be given more time to discuss, but this is the time for us to think of labor, because without labor, the East African community cannot stand. I thank you.
My instructions were these sessions, we have a special club. So you join me, we say, oh, yes. Thank you, Justice Linda. I think we all agree she should be a main speaker in the next conference, okay? Yes, she had a long paper. Our time is not on our side. Allow me to introduce to you the next discussant to tell us perspectives on harmonization of labor laws from the paper presented by Susan as far as Kenya is concerned. I'm introducing to you Senior Resident Magistrate from Kenya, Dr. Priska Wamsi Nyota. She's holder of PhD degree from the University of Nairobi. Her research interests are in international human rights law, regional law, including EAC, East African Community, COMESA, and IGAD, commercial law, and governance. She has published widely in these areas. She also teaches regional integration law as well as international human rights law at the University of Nairobi on volunteer basis as a way of giving back to the society. Currently, she is the treasurer of EAMJA South Rift region, chairperson of Alternative Dispute Justice Systems in Nakuru County in Kenya, and the secretary to the Judiciary Employee Protection and Equality Committee. I did not even know it exists. Then we have, what else? She also serves as a deputy registrar of the Environment and Land Court in Nakuru. Nakuru is one of our counties in Kenya. At the regional level, Dr. Wamsi serves as a council member of EAMJA Council. Karibu sana.
Good morning. I'm Jambo, Honorable Chief Justices, my colleagues, my brothers and sisters. I'm honored to stand before you this morning to say something about this very important topic. And I will go straight to my presentation. And the first thing I'll do is to appreciate what my senior sisters have done in terms of presentation. The presentations were extremely well thought out and informative. They have suggested ways forward on this journey of harmonization. And listening to the presentations and comparing with my research on Kenya's situation, I've realized that we are all experiencing the same thing. We are all busy ratifying treaties and conventions and cross-referencing decisions which we think are best practices. And so there are really concerted efforts and deliberate efforts to apply some of the common principles in labor law, including non-discrimination and all others. So from the few reported decisions, concepts such as unfair labor practices appear to have a common meaning to all. And for Kenya's situation, I just wish to highlight one decision that involved retirement age, and where reference was made to what is being done by other East African countries. This was a matter of David Mwangi Yoko and 51 others versus Nairobi City Water and Sewerage Company, and the issue in contention was about retirement age. These claimants had been told to retire at 55 years, but before they could retire, the government came up with a circular increasing the retirement age to 60 years. And the government argued that this 60 years is what had been adopted by other EAC partner states who were members then. That was Kenya and Uganda and Tanzania. So the court declared that the retirement age at 55 years was actually unfair. So of course, with the entry of new members to the region, the age of retirement is no longer uniform. So we still have a long way to go in terms of harmonization. In the area of social security, Kenya's NSSF Act allows anyone, regardless of their nationality, to join the scheme, and for portability of benefits to schemes of their choice, that is outward bound. But that act is silent on whether benefits are portable into NSSF from the home partner state or from the home country. And you realize now that becomes an issue, because if someone has decided that they have gotten employment in another partner state and they cannot move with their pension, they cannot move with their savings in the pension schemes, then that is a problem, because they are likely to lose out on some of these benefits like interest. By and large, what we have been doing is learning from practices we consider best in resolving the issues at hand, and we make reference to decisions that are considered persuasive by other jurisdictions or from other jurisdictions. And therefore, it takes the goodwill of a judge or a judicial officer to take this route. Because what is best practice to me may not be best practice to you. So we might not refer to the same decision when we are making our decisions. So the best practices are sometimes relative, as we all have different legal trainings, jurisprudential inclinations, and decisional independence. Nevertheless, for purposes of this conference, harmonization of labor laws and policies is an obligation placed on us as integral parts of our respective partner states and key drivers of the economic integration. And this obligation is placed on us by Article 104(3) of the treaty. And the harmonization is aimed at addressing the doldrums of diversity of legal frameworks. However, the treaty does not mention the extent or the method of such harmonization. Are we going to draft a common code? Are we to agree on a set of principles or standards, which then become the responsibility of individual states to incorporate into their domestic frameworks, or simply agree that citizens are entitled to same treatment as nationals under domestic laws? So with this gap, I wish to highlight some of the problematic areas in a bid to strengthen the discussion following presentations by the very able presenter and discussant. All the same, what I can say is that harmonization is not only a matter of cross-referencing what another judiciary is doing. It is much more than that. And an hour that you have been allocated is not enough to unpack this concept of harmonization. Nevertheless, as stated by the presenters, freedom of movement of labor is an entitlement under Article 10 of the Common Market Protocol. But I would like to draw your attention to the definition of labor under the Common Market Protocol, because that definition means it refers to a worker and a self-employed person. That means the scope of harmonization has to move beyond the employer-employee relationship that we know of, because when it covers a self-employed person, then we are already in another area altogether. So what Kenya's employment and labor framework looks like is that it does not address the aspect of self-employed persons, which is what the CMP looks at. Now, and I also doubt that any other partner state has addressed it as well. The entitlement is to a worker, their spouse, and their children. So the scope of the right holders is also expanded. It is not just one person, it involves the entire family. So Annex 2 on the free movement of workers is supposed to implement this freedom of movement of labor, and the purpose is to ensure uniformity in the implementation of the movement of labor. It makes provision for entry, stay, and exit, regulations on work permits, deportation, access to employment opportunities, expulsion of workers and their dependents, and most importantly, equal treatment in employment. So by virtue of Article 6D of the treaty, the Common Market Protocol and Annex 2 on free movement of labor take precedence over national laws on the same issue. So the question I have for you is this: have you ever applied the Common Market Protocol or Annex 2 in your decisions? Now, allow me to highlight some of the challenges that I see in the journey of harmonization, or that will hinder the discharge of our obligation in harmonizing our laws and jurisprudence. The first one is that the approach of the Common Market Protocol and Annex 2 is to have workers from other partner states treated the same way as nationals of the host states. In other words, there should be no discrimination on nationality grounds. But what is on the ground? In Kenya, under the Kenya Citizenship and Immigration Regulations, and I'm just highlighting some of the incidences of discrimination, spouses and children are classified as dependents of a holder of a work permit, and they are not allowed to work independently. And so, yet they have this right of freedom of labor, and they can be employed under the Common Market Protocol. So you see already there is the question of discrimination on the spouses, on some of the right holders like spouses and children. Then equal treatment at the national level is a great idea, but it does not promote harmonization because workers' experiences will be as good as the national laws of the host partner states, and will not be uniform across partner states because of the difference in content and practice of national laws. Annex 2 does not provide protection of the rights of spouses and children of workers who have been expelled or deported. They are all supposed to leave the territory. The question is, why should the wrongs of one right holder extend to an innocent right holder? Appreciating that employment involves an employer and employee as stated by the presenters, the Common Market Protocol and Annex 2 are dead silent on the rights of employers who engage these employees. Now, in most of our jurisdictions, decisions from best practices are merely persuasive and not binding. So the best practices might themselves differ depending on the viewer and the person considering them. Then the doctrine of stare decisis further complicates harmonization because in most jurisdictions like Kenya, the higher court's decisions are binding on lower court's decisions. There might be very little room for wiggling to give an opportunity for harmonization, particularly where parties themselves cite the binding law. Now, where courts are catalysts of legislative reforms, more often than not, the lawmakers ignore or drag their feet in implementing the decisions. So you'll have a judgment on this side, but you'll have a statute that still retains the provisions that were declared either unfair or unconstitutional or something. So sometimes people don't move together. Then there's a question of sovereignty of partner states, because matters of employment, matters of labor are considered to be matters of national interest, and therefore, sometimes there will be tendencies to exclude non-nationals from the job market, and not in a bad way, but it is in consideration of national interests, which will always affect harmonization. So I wish to propose quickly the way forward from my perspective. Harmonization should actually be primarily done through enactment of legislation or amendment of existing legislation. This is because mostly our decisions are based on what the statute says. What does the law say? Then you interpret and apply. So we need the Council of Ministers and the EAC's Sectoral Council on Legal and Judicial Affairs and EALA to consider collecting the universal standards, principles and rules and regulations acceptable across the EAC, and thereafter legislate. And the legislation can be by way of a uniform statute that will supersede all the national statutes, or it can complement what we have in our national jurisdictions. And that's the latter approach is what ECOWAS has done, and this is in appreciation that national governments have the responsibility to take care of public policy, health, and security issues. So now, lastly, I want to talk about capacity building. And you realize that this 1 hour, as you can already see, is not sufficient for us to discuss these matters. And therefore, I propose that EACJ, EAC, the Sectoral Council should come up with a curriculum in collaboration with judicial training institutes in our national jurisdictions, so that we can learn this more and share experiences in a better and more structured way. And you can bet with me that the next time we hear about labor law in this conference will be a few years to come. Thank you very much.
Let's clap for her. Oh, yes. Time is not on our side. I was told we'll be kicked out after 1 hour. That's why I also have to push, so that we can have time for Q&A. Please prepare your questions and we can pick them. You will tell us who you are directing the question to. On my far end is Dr. Nyota, or Honorable Nyota. Then we have, I don't think she refers to Msime. Yes, Justice Tumsime, and we have Susan. So just tell us who you want your question to be related to. But just to pick and summarize, on the key areas where we all agree, as presenters and discussants, as the key areas of harmonizations, issue of employee contracts, work hours, employment standards, wages, benefits, like maternity leave, you have had there's a small disparity. Also paternity leave, you have had there's a small disparity. Those are areas we need to harmonize. The question of social security, workers moving within the borders, are they able to move with their pension benefits? And then we have the non-citizen rights, We have the issue of termination procedures of contracts and the reasons for that, labor rights and freedom of association, collective bargaining, and anti-discrimination. I hope I've done justice to your paper, Susan, in terms of summary of the areas of harmonizations. We have 8 minutes. Any questions to this panel? Yes, you'll just also say your name and the speaker. Somebody can move the machines. You start with the lady.
Thank you. My name is Latifa Mansour from Tanzania, Judge of the High Court, Morogoro. My question goes to Madam Susan, the main presenter. We are discussing about harmonization of labor laws in East Africa. And I know about the East African community, which encourages any person to be able to work in any of the East African country. But I hear you talking about the Non-Citizen Act, which requires an employer to provide evidence that he cannot get a local to fill that vacancy. A local means if a job is in Tanzania, then that vacancy has to be filled with a Tanzanian. You must provide evidence to the satisfaction of the government or the labor commissioner that you cannot get a Tanzanian to fill that position. My question is, don't you think this is a conflict? Instead of harmonizing and encouraging the processes of community, of East African community, instead now Tanzania, we are introducing a Non-Citizen Act which prohibits employers from freely employing people from any East African country, one. And two, whether this Non-Citizen Act is also available in Kenya, Uganda, Rwanda, and other East African countries. Thank you.
Thank you. Next, we can have a judge from Uganda.
Thank you very much. My name is Anthony Wabwire, judge from Uganda. I am not directing any question. I have a few general comments. But first, a short demonstration. Mheshimiwa Chief Justice, Mheshimiwa majaji wote, Registrar,
kindly go to the question. You have 1 minute to ask that question. Just go to the question.
It's a comment. Mwaka 1975 marehemu Augustus Musana na mkewe waliwasili hapa Arusha kikazi. Walikuwa na watoto wengi na leo mtoto mmoja amerudi hapa Arusha na furaha sana kama mjumbe wa Uganda. My point. If we do speak the same language, Kiswahili, now an official language of the East African community, the idea that Kiswahili was born in Tanzania, died in Kenya, and was buried in Uganda, by that short, incontrovertible evidence, is not a very good proposition. The courts shape the laws. At the same time, the courts can shape the values of society. A common culture, a common language, and the right to work means the need to harmonize is urgent. The Minister of Constitutional and Legal Affairs made that point on our commonality. C.J. Juma said, birds of the same feather must flock together. Doctor, you asked the question whether Annex 2 has been part of our decisions, Annex 2 of the protocols. In Kokeyo versus Peacock Paints, we were faced with a question of an immigrant worker in Uganda seeking to enforce a determination of unfair termination. The protocol suggests equal treatment, asks the courts to afford equal treatment, but the National Immigration Act require the worker to demonstrate a lot more than merely that they work. My short point being the need to harmonize for commonality is urgent. Thank you.
Thank you, Judge. And the delegates from Uganda, the perspective for Uganda have been represented. You can only ask a question. Thank you. Let's proceed. Yes, thank you.
Thank you very much. My name is Harrison Tabaza. I'm a judge from the High Court of Rwanda. My question is to the main presenter, Susan. I wanted to know a little bit about the Commission for Mediation and Arbitration, especially its efficiency and dispute resolution. Thank you so very much.
Thank you. We can pick 6 questions, then we do another round. Proceed to Judge.
Thank you, Judge. My question is to the main presenter as well. My name is Olive Kazare Mkwaya, Uganda. You mentioned something about the use of tripartite court user committees to engage on the issues that we have. Just want to hear more about that. Thank you.
Justice Murima, Judicial Service Commission member.
Thank you so much, my sister. I really do not have a question for this panel, but I'm seeking clarification in respect of a session which for good cause we skipped yesterday afternoon, the Q&A session. And we promised ourselves that we will be doing it in the morning. I think we need to get some guidance, because to me, it's a session which we need to introspect a few things. Thank you.